Good evening, Judge Delphine, and good evening, classmates. I'm going to discuss the Canon 13, 1302, and 1303 of Code of Professionals. 1302. A lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against a party. With regards to prejudicial publicity, in the case of Estrada versus Dischetto, the petitioner insisted that he is the victim of prejudicial publicity. He assails the decision for adverting to newspaper accounts of the events and occurrences to reach the conclusion that he has resigned. The petition hangs tough on his submission that his due process tied to a fair trial have been prejudiced by pretrial publicity. The issue here is that whether prejudicial publicity has affected petitioners' right to fair trial, and the court held that there is not enough evidence to sustain petitioner's claim or prejudicial publicity. Thus, it held that petitioner due process rights to a fair trial have not been prejudiced by pretrial publicity. These restrictions does not prohibit issuances of statements by public officials charged with the duty of prosecuting or defending actions in court. Okay, so let's have example. Let's have an example case here. Gonzalez, a noted professor of commercial law, wrote an article on the subject of letters of credit which was published in the IBP journal. Assumed that he devoted a significant portion of the article to a commentary on the Supreme Court should decide a pending case involving the application of the law on letters of the credit. The question here is that, may he be sanctioned by the Supreme Court? The answer is yes. Because Prof. Gonzalez may be sanctioned by the Supreme Court because of the Rule 1302 provides that a lawyer shall not make public statements in the media regarding a pending case tending to arouse public opinion for or against party. The court in a pending litigation must be shielded from embarrassment or influence in its duty. Okay, let's have another one here. Oh my gosh. Let's have another one here. Assume Gonzalez did not include any commentary on the case. Assume further, after the Supreme Court decision on the case had attained finality, he wrote another IBP Journal article dissecting the decision and explaining why the Supreme Court erred in all its conclusions. The question is that, may he be sanctioned by the Supreme Court? The answer is, he may not be sanctioned by the Supreme Court. Once a case is concluded, the judge who decided is subject to the same criticism as any other public officials because his decisions becomes public property and is thrown open to public consumption. The lawyer enjoys a wide latitude in commenting or criticizing the judge's decision, provided that such comment or criticism shall be bona fide and not spill over the bounds of decency. Okay, let's proceed to Rule 1303. A lawyer shall not brook or invite interference another branch or agency of the government in the normal course of judicial proceedings. The reason for this rule is that such action will be contrary to the principle of separation of powers. All lawyers must uphold, respect, and support the indifference of the judiciary. This independence from the interference is made to apply against all branches and agencies of the government. Okay, let's talk about the duties and responsibilities of a lawyer to the client. We have number one, strictly personal. This prohibits the delegation of work without the client's consent. Number two, Number two, highly confidential. We have two. First, a communication mode in the course of lawyers' professional employment. And second, the communication intended to be confidential. And number three, fiduciary. It involves trust, especially with regards to the relationship between a trustee and a beneficiary. It holds trust, monies, and properties of his clients that may come into his possession. When a lawyer enforces charging lien against his client, the relationship is terminated, and an attorney cannot represent adverse interests unless the parties consent to the representation after full disclosure of facts. Okay. Necessity of contract between a lawyer and a client. The absence of written contract will not precluded a finding that there is a professional relationship. So thus, documentary formalism is not an essential element in the employment of an attorney. The contract may be expressed or implied. It is sufficient to establish the professional relations that the advice and assistance of an attorney is sought and received in any matter pertinent to his profession. Okay, let's talk about the formulation of the lawyers and client relationship. The lawyer-client relationship is formed through the following. Number one, oral. When the counsel is employed without a written agreement, but the conditions and amount of attorney fees are agreed upon. Number two, express. When the terms and conditions, including amount of fees, are explicitly stated in a written document, which may be a private or public document, written contract of attorney's fees is the law between the lawyer and the client. Number three, implied. When there is no agreement, whether oral or written, but the client allowed the lawyer to render legal services not intended to be gratuitous without objection, and client is benefited by reason thereof. Okay. Rules. Let's proceed to the rules protecting the attorney-client relationship. Number one, best effort must be exerted by the attorney to protect his client's interest. Number two, attorney must promptly account for any fund or property entrusted by or received for his client. Number three, an attorney cannot purchase his client's property or interest in litigation. Number four, the privacy of communication shall at all times upheld. And number five, an attorney cannot represent a party whose interest is adverse to that of his client even after the termination of relations. Okay, the three principal Types of professional activity of a lawyer. So we can call it LAP. Okay, number one, L. Legal stands for legal. Legal advice and instructions to clients to inform them of their rights and obligations. Number two, A, stands for appearance. Appearance for clients before public tribunals which possess power and authority to determine rights of life, liberty, and property according to law, in order to assist in proper interpretation and enforcement of law. And number three, P, stands for preparations. Preparations for clients of documents requiring knowledge of legal principles not possessed by ordinary layman. Alright, so we have an example case here. Mr. C engaged the services of Attorney Decena to prepare and file a petition for the issuance of a new certificate of title. C confided with him the circumstances surrounding the lost title and discussing the fees and costs. When the petition was about to be filed, Attorney Decena went to C's office and demanded a certain amount from him other than what they had previously agreed upon. C found out later that instead of filing the petition for the issuance of a new certificate of title, Attorney Decena filed letter complaint against him with the Office of the Provincial Prosecutor for falsification public document. The letter complaint contained facts and circumstances pertaining to the transfer of certificate of title that was subject matter of the petition which Attorney Decena was supposed to have filed. The question here is that, should Attorney Decena be suspended for violating the lawyer-client relationship when he filed a complaint for falsification of public documents against his client using facts connected with the latter's petition? Excuse me. The answer here is that no. As a rule, attorney-client relationship is said to exist when a lawyer voluntarily permits or acquiesces with the consultation a person who, in respect a business or trouble of any kind, consults a lawyer with a view of obtaining professional advice or assistance. It is not essential that the client should have employed the attorney on any previous occasions or that any retainer should have been paid, promised, or changed for. Neither is it material that the attorney consulted did not afterward undertake the case about which the consultation was had, for as long as the advice and assistance of the attorney is sought and received in matter pertinent to his profession. Okay, that's all. Thank you and be safe, everyone. Thank you.